Now recognize the ranking member, Mr. Green.
Thank you.
For the final round, for the final questioning of the day.
Thank you, Mr. Chairman. Let me move quickly to this notion that you have to have explicit authorization for a law or a standard to be implemented. My suspicion is that you would all agree that the Constitution of the United States of America does not call for judicial review. Is there anyone who differs with me in terms of judicial review, that it is not explicitly mentioned in the Constitution? And we all know as first-year law students that it's in the case of what? Marbury versus Madison. That's where it comes from. So you don't have to have explicit language for a court to recognize that a standard can be established. Next point, let's talk about this whole notion, it seems to me from some of you, that courts are granting summary judgments based upon numbers that are presented. There are no summary judgments being presented on some sort of regular basis with reference to disparate impact. Mr. Parker, you're a practitioner. How many years have you been practicing law?
33.
And have you handled few or many cases of this type?
Many cases.
Do you find that summary judgment is the usual circumstance wherein a defendant has given an affirmative defense by way of answer?
No, I find that, in fact, that the plaintiff is at a disadvantage in many cases, that it is very difficult to bring and to prove these cases.
And do you also find that after disparate impact has been presented, that a defendant still has the opportunity to refute the evidence that has been shown such that the defendant can still prevail?
They do have that opportunity at least once.
And do you find that, at least once,
Yeah.
do you find that even if the plaintiff then, the moving party, presents additional evidence, the defendant still has an additional opportunity to refute the last evidence presented?
That is correct.
So there's a system in place that the courts have recognized now for some 40 years, working efficaciously, that there seems to be a desire to overturn. Can you quickly tell me one more time, because you've said it to others, what would be the implications of eliminating the disparate impact standard, not theory? Not theory, because it's now a standard.
The impact of eliminating what has been a long-standing practice in the courts, in the agencies that enforce the law, would be to make it difficult, if not impossible, to show that policies that are unnecessary and unjustified have an impact on protected classes to the detriment of those classes. It would eliminate a whole class of cases which affect an enormous number of people.
I marvel at how a good many people who are opposed to disparate impact also oppose testing. Testing is the methodology by which we can ascertain whether or not discrimination exists also. It seems that I'm seeing a line of consistency here. Opposed to testing, opposed to disparate impact, but opposed to invidious discrimination. How do you prove invidious discrimination other than a guy shows up with a white cape and a hood? How do you prove it? You have to have some tools available to you to deal with people who are intelligent. These people are not idiots. They understand the consequences of their actions, and many of them disguise their actions with clever policies. But the law wasn't intended just to deal with people who make intentional, overt manifestations. The law is also designed to deal with good people who set bad policies. Can you give an example of a good person who may have had a bad policy quickly, because I have a closing statement, Mr. Parker?
Yes, one such policy might be, as I mentioned before, the policy that says you have to be employed in a full-time job to get an apartment. That would have an impact on someone who, because of disability...
A veteran, for example.
Right.
A veteran who has other sources of income. You should consider all sources of income in deciding to rent, not just the person having a full-time job. Because there are people who don't have full-time jobs who can afford the apartment that you're leasing.
And everyone's interest is protected in that case.
Thank you. My closing comment is this. It has always been the intelligentsia that perpetrates. The ignorant may perpetuate, but it's the intelligentsia that perpetrates. It was the intelligentsia that gave us Dred Scott. It was the intelligentsia that gave us a lot of these laws that we find ourselves having to overturn, and in fact we've overcome. So I would hope that this hearing will not allow us to find ourselves having to combat some rule or some law that eventually could overturn 40 years of progress. I yield back.